Live video starting, and I'm just going to check. We are in fact live. Okay, I think we are. Quite impressed with my technical skills lately. So good morning. No, it's just about good afternoon. So good afternoon, everybody. I'm Katie Friedman, and I am the founder of Flexible Working People. I'm really thrilled to have Belinda Lester join us today. Hi, Belinda. How are you?
I'm good, Katie. How are you? Nice to see you.
Nice to see you. So Belinda is our resident Flexible Working People legal expert, and Belinda specialises in employment law, and she's the founder of Lionshead Law, and Lionshead Law is one of our Flexible Working People partners. And we love to do these lives every so often because as our partner, we have so many issues, both from employers and employees, that come up in the Flexible Working People group all the time. And so we choose topics that we think will really resonate and will help and support both employers and employees on their journey. Today, we're going to talk about the different ways in which both employers and employees deal with workplace issues and grievances. So how and when to raise one if you're an employee, and how to deal with it if you're your employer. Just to give you a bit of background on Belinda, Belinda advises businesses and individuals on all aspects of employment law. She qualified as a solicitor in 1999 and worked exclusively as an employment lawyer. She is commended by clients for clear, practical and solution-focused advice. Belinda started Lionshead Law 11 years ago, and its team, while specialising primarily in employment law, also offers commercial, immigration and wills and probate services. So good to have you, Belinda. Let's get started. So you were keen to talk about grievances, and this is something that you deal with a lot in your everyday. Thought it might be helpful just for you to sort of tell us why you think this is an important topic, and maybe explain a bit about what a grievance is.
Yeah, so obviously a grievance is any sort of issue that an employee has at work, any complaint, any concern, whether that's formal or informal. If you have an issue at work and you want to raise it with your employer, then that is technically a grievance. Most employers are required by law to have grievance policies and procedures in their staff handbook or referred to in their employment contract. So every employer should have a grievance policy or procedure. So whether you're following their informal or informal procedure, if you've got a concern and you're raising it, then really technically that's a grievance.
Okay, great. So what are the sorts of issues that are most commonly the subject of workplace grievances? Can you just give us a flavour of what someone might be raising as a concern, either informally or formally?
Bullying, harassment, discrimination. People might have concerns about changes to terms and conditions, failure to give proper job descriptions, perhaps employers seemingly changing job descriptions without consultation, all sorts of things. I mean, there are so many issues, management issues. Very often grievances arise when people feel that they're being targeted unfairly under performance plans. So many grievances arise from miscommunication, not very good management, grievances when people are coming back from maternity leave. I mean, the list is endless, right? The workplace is a tricky place. The relationship between employer and employee, I always think it's quite akin to a marriage in a way. And a lot of issues in marriages and in employment are very similar. They're usually about miscommunication.
Agreed. Okay, so you talked about informal, and some of the things that you just talked about sounded quite serious, sort of more formal. What would be some examples maybe of some less formal grievances, so an informal grievance? Or is that just how you raise it?
Well, it's just how you raise it, really. I mean, a lot of employers' policies say if you have a grievance, raise it informally first with your manager to try and resolve it.
Okay. Got it. Okay, so let's get on then to the process of raising a grievance. How, if you had a complaint, either formal or informal, what's the process? How do you raise a grievance?
Well, I think your first port of call is to look at your company's grievance policy and look in there to see how am I supposed to raise it. if it's a minor complaint or a minor concern or an issue with your manager or just something that's bothering you, then I think informal is always the way to go. The people who, when they instruct me or come to me or get advice from me, it's usually because things are, they've either tried an informal route and it's got nowhere, or they are really at their wit's end and something's quite serious and they want to know how best to deal with it. And my first question always, when I get instructed by an employee, is, what's your end goal? What are you hoping to achieve from raising this grievance? Because looking at what the outcome they are seeking at first enables me to advise better on how to approach it. If the employee really just wants the grievance resolved, they don't want to leave their job, they're really happy there, they just want the employer to recognise that there's an issue and deal with it, then how you raise that grievance is going to be very different from if you feel that the situation has just become untenable and you want to leave and what you're trying to do is negotiate an exit.
Okay, that's really good advice. So having a really clear idea about what you want the outcome to be will affect how you manage that grievance process.
Yes.
Okay, so if you're an employer, and obviously there's loads of different sizes and types of employers, so this is a question. I'm sure if you're a larger employer, you're going to have very specific people in place who are very used to dealing with these things and would have clear processes of who to manage. So maybe let's talk about if you're an employer and you're not so used to this, maybe a smaller sized firm, how do you deal with a grievance if an employee of yours makes one?
Well, actually, my advice is the same, really, whatever size you are, and also what you as an employer want to do, because with every client, employer or employee, you have to think about what is our end goal, what are we trying to achieve out of this. Whenever I get instructed by an employee, depending on what the grievance is, if the grievance is making allegations of discrimination, for example, I always tell the client it's very, very unlikely that you're going to get a finding in your favor, that the grievance is going to be upheld, because in upholding a grievance, an employer is effectively admitting liability.
Right.
But on the other hand, when I'm advising employers, I always say to them, look, there is a fine line here between being quite defensive because you're worried that a claim might be brought and you don't want to be admitting liability in an open grievance outcome. Conversely, if you are trying to look at resolving this person's grievance, particularly if you don't want to lose them, or even if you want them to go, it's a really good idea to think about how best am I going to achieve the outcome that this employee is looking for, and is it something we want to do, right? So whilst I tell employees, make sure you think about the outcome you're looking for and put it, I say to an employer, there's nothing wrong with speaking to the employee and say, we're obviously going to investigate this. We really take on board your concerns. We're going to investigate it. What we'd like to understand from you is what you would like, what your solution to this would be if we find that there's merit to this, or even if we don't find there's merit, perhaps we still want to, try and improve the work situation, or talk to you about what else it is you're looking for. I think it's a really good idea to explore that, because if you're of the view that this employee is really just looking to leave, and you're okay with that, and you're prepared to negotiate some form of an exit, then getting the employee to say, well, actually, that's what I'm looking for. At that point, you could say, well, shall we just park the grievance for now and talk off the record? And then there doesn't have to be any admissions. It's quite good tactically, because sometimes if an employee has raised a grievance and it's really serious and you as the employer are worried, if you're able to have that conversation, you're not always able to have that conversation, but if you're able to have it, it can neutralize everything. You can come to an agreement employment, and you don't actually have to make any findings. And of course, if those negotiations break down, then you can go through the grievance investigation and see if there's any evidence.
And who's involved in this grievance process? So if you're an employee and you have a grievance, like, do you get someone involved? Should a lawyer be involved? At what stage? And on the employer side, is it beneficial for them to get legal help and advice? Because this feels like quite complicated ground. And I feel like for somebody who's entering into a grievance process without the support of a lawyer, it could be quite tricky.
Well, it depends on the seriousness.
What it is. Yeah.
So, I wouldn't tell people, you must involve a lawyer if I don't think they need to. You really should be thinking about, is this a grievance that I think can be resolved by my employer? Am I going to raise it in a way that offers solutions, offers things that they can do? For example, let's say you're somebody with a disability and you feel that reasonable adjustments haven't been made. You don't want to leave. You love your job. Yeah. You're not trying to negotiate your way out. You just want to highlight issues. You might just say, look, I just want to raise a concern. You know that I've got this disability. This is the impact it's having on me. I know you've put in place adjustment X, Y, and Z, but actually I feel further adjustments are required. I'd like the company to look into this because I've spoken to my line manager about it. Nothing's been done. I'm not sure at that stage you need a lawyer.
Correct. Okay, so very much depends on what it is. Whereas if it's a discrimination issue,
that is a discrimination issue if they don't do it, right? Yeah. But there's no point going all heavy-handed if what you're trying to do is get your employer on board. Obviously, if things deteriorate and the employer ignores the grievance or does nothing to help resolve the grievance, and you feel, actually, I'm finding this more and more difficult for me to continue working here, then you might want to get some legal advice. I would never normally write a grievance as if it's from the lawyer. When I get instructed, I almost always say, I will draft the grievance for you, but as if it's coming from you rather than from a lawyer. Because I think unless it's really, really serious, you're going in big guns and you're not giving the employer a chance.
Got it. Okay. And in terms of the process, is there a timeline or obligations that either have to fulfill in order to go through this process?
If you've got a complaint, particularly if it's a complaint relating to discrimination, I would act sooner rather than later. Because with discrimination, for example, if down the line you want to go to an employment tribunal, you've only got 3 months from the last act of discrimination to bring a claim. Obviously, discrimination can be ongoing. So, if an employer is failing to make reasonable adjustments, they're continuing to fail to make reasonable adjustments each day. So the time limit is arguably not even started until you've left, right? But I just think it's always a good idea to raise concerns, if they're real concerns, early and informally, if you can.
Yeah.
Because whether you like it or not, once you start going down a formal route, it always does affect the relationship.
Absolutely.
Sometimes that damage is permanent, and sometimes you can, it's a grievance which can be resolved. But if you really want to stay with your employer and you just want the grievance resolved, then be very, very clear about how you think it can be resolved and be quite positive and proactive about that.
Okay, so if the grievance is raised and you don't get the outcome that you're seeking, it doesn't go your way, what's the next stage after that?
There's usually an appeal process.
Yeah.
What I say to employees is, if you're raising a grievance because you are actually thinking about pursuing a claim, or you're trying to negotiate an exit, you still need to raise it, because in the tribunal, for example, if you haven't raised a grievance and given your employer an opportunity to try and resolve it, and you just go straight to tribunal without doing that, even if you win, your compensation can be reduced by up to 25% because of your failure to comply with the ACAS code on grievances. Similarly, it's the same the other way around. If an employer dismisses you without going through a fair process and you win your case for unfair dismissal, your award will be increased by up to 25% because of the employer's failure to follow the ACAS code. So raising a grievance is a very important first step anyway, if you're thinking, well, actually, there's a chance here that my grievance is so serious, and if it's not resolved, there's a chance I may want to bring a claim. It's essential to go through the grievance process first.
Okay, so let's just talk again, because you went through that quite quickly. Let's just talk again about the tribunal process, and that's making a claim, assuming that means once you make a claim, then you're going through the tribunal process. So if you don't get the outcome you're seeking, what's your answer to should you go through to tribunal?
I think, look, you can. I mean, if your grievance, for example, is that you have been that your employer has failed to make reasonable adjustments, and this is discriminating against you, but you don't want to leave, or you have perhaps discussed off the record with your employer that the outcome you're seeking is a negotiated exit, and you haven't been able to reach agreement on a negotiated exit, so you don't want to resign, you actually want to stay. You can actually bring a claim in the employment tribunal whilst you're still an employee for discrimination. Obviously, very uncomfortable. It's something that you can do, because particularly if you want to push your employer into reaching a settlement with you for you to leave, if they haven't done it at that point. I mean, there's so much to think about. There's so much to think about strategically. I think as an employer, looking at this from the other side, I think it's incredibly important. Most employers who come to me when they've had a grievance are very, very concerned. What do we do about this? Because how do we investigate this grievance without, what if we find that there are some merit to these complaints? How do we say that without putting ourselves in the firing line? Because then they go, right, you've admitted this, and we're going to go to tribunal. I always say, look, the reality is that if that is the nature of the grievance, and you have looked into it and you think there's actually some evidence to support what they're saying, it's a very good opportunity for you to come to the negotiating table now, rather than wait for them to issue a claim, and you've then got to pay lawyers to defend it, and then you've got to go through this process.
So you're saying if there is some merit to it, it's better to sort it out before it gets to the claim.
Either sort it out by saying to the employee, look, can we before we look into this grievance, can we sit down and talk about what it is that you want to achieve? Because if the employee says, I'm done, I want to leave, then that's a really good opportunity to say, well, let's just park the investigation for now with your agreement and talk about that.
And what leaving looks like, as opposed to
what leaving looks like, rather than waiting until you've gone through this investigation, given some very vague outcome, which is just going to wind the employee up more. Think about it from their point of view, particularly if you've got evidence that some of their complaints have got merit.
Yeah.
If, of course, you truly believe that there is absolutely no merit to the grievance, and if you conduct an investigation, the likelihood is you're not going to find that they've got any grounds, and you don't want them to leave, then again, when you're doing the investigation and the outcome, still think about, okay, we haven't found any evidence of this. We don't think the employee's right, but that's not going to make the employee feel good. That's not going to make the employee feel, well, my grievance has been heard. How do we give that outcome in a way that makes the employee feel heard, recognized, and gives them some sort of closure, or some sort of, because at the end of the day, instead of just thinking about how can we be defensive, how can we defend our position, how can we tick the boxes of having gone through an investigation and giving an outcome, if the employee really feels that they've got a complaint, then you need to think about how to diffuse that situation, particularly if you want them to stay, and they have said they want to stay. It's so
nuanced, this, isn't it?
It's too easy to get defensive and to get attacking, right? Because it's personal. It's, as I said, it's the employment relationship is so akin to other sorts of, because it's people. We're dealing with people and emotions.
Yeah. Okay, some really, really good advice there. So you talked earlier about, I think you said there was a period of time in which you can't raise a grievance after you've left. So in an example where an employee might, have all these issues and just decide to leave a job, which does happen, without having had the conversations or brought up any formal complaint procedure or gone through a grievance, let's say they leave and then after the fact think, well, I've gone, but actually I feel really unfairly treated. Can I now, in hindsight, go back post, having left employment and now raise a grievance?
Yes.
Is that allowed? Is there a certain timeline on that?
So you've got you've got the grievance process. You can raise a grievance after you've left. It's a good idea. It's always a good idea if you're look. You've got two potential claims. One is constructive dismissal. I resigned in response to the conduct. I resigned in response to your fundamental breach of contract. That breach of contract either being a breach of the duty of trust and confidence between employer and employee, discrimination, all of these sorts of things. If that is your reason for resigning, it is a good idea to put that in your resignation letter, because otherwise, if you don't and you just say, I'm handing in my notice, the employer can say, well, you never said you were resigning in response to breach of contract. Why are you suddenly,
And could that have an effect on the outcome if they don't?
It's all evidence, isn't it? Why did you resign? Why are you suddenly saying this now? Is it because you just haven't got another job and you want some money? It's always a good idea to give your reason, or at least give it in an exit interview.
Yeah.
If you haven't done, but if the reason that you resigned was that you felt, for example, that you were discriminated against, possibly when you came back from maternity leave or whatever it is, yes, raise a grievance, but don't wait. Don't wait for the grievance outcome before you contact ACAS for early conciliation, because you've only got 3 months to bring a claim the time limits. So you've got 3 months to issue a claim, but the clock stops when you contact ACAS for early conciliation, and you have to get an early conciliation certificate from ACAS before you can pursue a claim. So what I say is what you've really got is 3 months to contact ACAS for early conciliation. Now, if you've left and you raise a grievance just before the 3 months,
sorry to interrupt, why do you need to contact ACAS?
ACAS is the early conciliator. Okay. ACAS will contact your employer and say, we've got somebody who's come to us who's got a potential claim. Are you interested in early conciliation?
But you do that only. You only contact ACAS after you've left, not if you were still employed.
Contact ACAS when you're still employed if you're bringing a discrimination claim, but you don't want to leave. Because you can bring a discrimination claim and still be employed. Most people don't do that. It's quite uncomfortable, right, to sue your employer and to carry on working for them, but you can.
Yeah. Yeah.
But obviously, for an unfair dismissal, you'd have left, because you can only bring an unfair dismissal claim after you've
left. Yeah.
But you get ACAS then get involved and try and see if there's they can conciliate and help bring about a settlement before you have to bring a claim. However, if you haven't raised a grievance first, the employer then will say, well, yes, okay, we're prepared to enter into early conciliation, but we've thought about the sort of compensation you could get because you haven't raised a grievance and haven't allowed us to deal with this internally. Any compensation you get will be reduced by 25%. So you should be doing the two concurrently. Raise the grievance and at the same time, or shortly afterwards, contact ACAS. Do not wait for the employer to go through the grievance process, because the employer, if they've got advice, will take ages to go through the grievance process.
So that you fall out
after the 3 months, and then you've got this whole issue of trying to argue that you're not out of time. And
okay, there's a lot to think about here.
Yeah.
Okay, so we talked about, I think, when to issue proceedings and what to think about, and then I think the last question is when defending a claim, whether and when to think about settling it.
So I'm a big believer in dispute resolution, early dispute resolution. Some employers, as a matter of course, will defend claims, the big ones, the big banks, but the big employers tend to just want to defend claims because there's all sorts of reasons. For a lot of employers don't want to give the impression that they just settle, and so they will be quite vigorous in their defence of claims, even claims which they believe possibly have merit. Most employers that I deal with are, not the huge institutions, and I often say to them, look, let's think about what the value of this employee's claim could be, even on their best case scenario. What would it cost you as an employer to defend this? what would you be interested in settlement? Because it's, at what stage do you want to enter into those negotiations? Do you want to do it very early before proceedings have issued? Do you want to wait until they've issued? This is what it's going to cost us to put in a defence. At what stage are you wanting to settle it once defence has gone in? I think that's often a good time if you've got a good defence. If you've actually got a good defence, but that actually the value of this person's claim is quite low, usually because they're on a low salary, so their losses are probably quite low, even if they win. If you've got a really good defence, I always say, well, let's wait until the issue and let's put in a really strong defence, because it's going to put you in a much stronger negotiating position in terms of reaching a settlement. If it's somebody who was on a really, really high salary and the value of their claim, if they win, would be really, really high, and you've got a good defence, well, obviously you're going to want to defend it. Maybe you want to settle it down the line. If they're on a really, really high salary and you know that this is not, you've got some risk, entering into early negotiations might be good, although you might want to wait and see, are they going to get another job? Because if they get another job quickly, the value of their claim drops significantly. So there's all sorts of things to think about. And I say that to employees too. I say, well, look, you're really miserable. You hate your employer. You're fed up. But look, you're eminently employable. You've got a phenomenal CV. You've got a 3-month notice period. Why don't you just, yes, you can go down the legal route, but there's a lot of stress involved in that. You're going to sour your relations with your employer. If you're working in an environment which is a very small world and word can get out about what's gone on, you might just want to think about looking for another job and just handing in your notice when you get one, right? You don't have to go down.
Yeah, I agree. But I think there's so many situations, Belinda, where there are fair grievances that should probably be raised, and so many employees are too nervous or don't really know where to start with this, and don't have capability to hire lawyers to advise them. And we see this all the time. There are questions all the time in our community around issues with their employers that never even make a grievance because of the potential.
I think in that situation, if you're concerned that your employer behaves in a certain way, is discriminatory, but you think to yourself, actually, I don't want to, because there are lots of things to think about. I don't want to sour my relations. I want to preserve my reputation in the marketplace, but I want the employer to know about this. But I know that if I start this process, there's no guarantee that I'll get an exit package. There's no guarantee of any of this, and it could really queer my pitch if I'm looking for another role. These are all things to think about, right? And particularly if you know that you're really, really employable and you know that you'd get another job quickly, it might be a good idea to get another job and then have an exit interview and say, look, just so you know, this is why I'm leaving. These are the concerns that I've got. I didn't want to raise a formal grievance. I didn't want to go down that route. I just thought, you know what, I'm just not happy here anymore. I've found another job. It's a great opportunity for me. I'm going to go for it. But just want you to know that these are the reasons. This is the reason why I'm leaving here. And these are issues that I think you as an employer should look at.
Yeah, I mean, it's a fine balance, isn't it? Depends.
And it really depends on
your situation,
on your own personal situation and what it is you're trying to achieve. That's why I always say to people, what is it you want to achieve? Because not everybody's looking for a financial settlement. They just want their employer to behave differently.
Yeah, and some will say, I love the company that I work for. I really want to stay. I just have an issue with my manager, and therefore that's it's not just as easy as we'll just go and get another job. Because you're like, well, I've actually got a great role and I love my team, but this is a problem and I don't know how to get past it. And in which case you want to work through that issue. You want to work through it, but again, don't get too confrontational, right? Because you're dealing with a person. You're raising a grievance about somebody who will have a very different perspective. They will. However legitimate you believe your grievance to be, and it may well be, the person you're raising it against will not see it that way. You have to remember that. And will defend their position.
And if they feel they're being attacked, they will be very defensive. And once it starts to get that way, it's quite difficult to preserve the employment relationship, unless it's a very big organization and one or other person can be moved.
Exactly.
But I think it's very important to, again, I'm hammering home the point, but I always say, what is your end goal?
Yeah. Okay, good advice. Great. All right, well, look, we've timed that to perfection. What would your final words be to an employee and employer, to both, around this? I think you've just said it, actually, and I think that's the important point, isn't it? It's like, what are you trying to get from this? What is your end goal?
Really, employer or employee, where do you want this to end?
Yeah.
What's the best way of achieving it?
Okay, well, another great session with Belinda, with a whirlwind stop tour of grievance processes. Belinda, if people want to reach out to you, you're on LinkedIn, you're very active in our Flexible Working Facebook group. We'll drop some links in the thread below so that you can reach out to Belinda if you've got an employment issue that you want advice on, or if you are an employer and you want to have a chat to Belinda about how she might be able to help you and support your firm. So Belinda, thank you so much for your time this morning. As always, great advice, really pragmatic and practical, which I love, and that's why we love working with you. So thanks so much if you are listening live, or if you're watching this on replay. We hope that you got some great value from the session. Thanks a lot.
Thanks so much, Katie. Bye-bye.
Bye.